India Legal, stories that count.
Hello and welcome to another special readout from India Legal magazine. As you know, we are the nation's first political legal independent weekly focusing on controversial issues of national and international importance. The video readouts we present to you regularly are the editorial team's choice of the most significant stories we believe should receive close scrutiny and wide circulation. You can watch them along with the visuals or listen to them as you would a podcast. In this commentary, we focus on India's president. On July 18, 2022, India's elected representatives will vote to elect the country's 15th president. Ahead of the much anticipated election, we look at the importance and significance of the post of India's first citizen. This post has been occupied in the past by world luminaries, philosophers and statesmen like Rajendra Prasad, Sarvepalli Radhakrishnan, Zakir Hussein, Giani Zail Singh, Pranab Mukherjee, to name a few. Despite the iconic personalities who have held this position, there has been a running debate that the president is nothing more than a titular head who has to go along with the prime minister, another voice of the prime minister. The other view is that the president is not just a rubber stamp. There are a few areas where the president can act with his own discretion and at his own discretion. In today's show, I bring you an analysis penned for India Legal by Lokendra Malik. The writer is an advocate in the Supreme Court. Readers can refer to his book, The Power of Raisina Hill, The Constitutional Position, Functions and Powers of the President of India, published by LexisNexis, 2015. But first, a brief backgrounder on India's presidential election. The Election Commission of India conducts the poll for this highest constitutional functionary in the country, the guardian of the Constitution and the supreme commander of the defense forces. But in reality, the powers of the president are exercised on the advice of the elected government headed by the prime minister. The PM and his ministerial colleagues are collectively responsible to the Lok Sabha. There is hardly a situation, writes Malik, where the president acts at his own discretion and disregards the advice of the Union Council of Ministers. Nonetheless, as Malik points out, the president does have the scope to return the advice or decision of the Council of Ministers and ask them to go back to the drawing board. But if the Council reiterates its view, the president will be bound to accept the same. This position is now well settled after the 44th Constitutional Amendment Act of 1978 and numerous judgments of the Supreme Court on this very issue. But we ask again, is the Indian head of state merely a mouthpiece of the central government who dances to their instructions, whether elected or not, providing constitutional legitimacy to the political agenda of the ruling party? Malik asserts that a president who is well versed in constitutional law and practice can make a difference. The president has a constitutional right to seek information from the prime minister under Article 78 of the Constitution. The president reads all the papers and can seek clarifications and explanations from the government, and that's as and when required. And for instance, during his tenure, President K.R. Narayanan, one of the best in presidents we've ever had, exercised referral power 2 times. He returned the advice of the cabinet for its reconsideration regarding the imposition of president's rule in the states of UP and Bihar during the Gujral and Vajpayee governments, when Inder Gujral and Vajpayee were prime minister, and actually prevented those state governments from being toppled and president's rule or governor's rule being declared there. In 1997, The then governor of Uttar Pradesh, that was Ramesh Bhandari, recommended the dismissal of Kalyan Singh's government in UP to the Union Cabinet headed by then Prime Minister Inder Gujral, I.K. Gujral. The PM passed the recommendation to the President, Narayanan, for his approval. In fact, Gujral urged the President to dismiss the UP government headed by Chief Minister Kalyan Singh. Kalyan Singh was, as we all know, was a prominent BJP leader who played a decisive role in the Ram Mandir movement of Ayodhya and the subsequent demolition of the Babri Masjid, and he was a poster boy for the BJP. President Narayanan read the entire file and also read the judgment of the Supreme Court delivered in the famous S.R. Bommai case in 1994, which is the authoritative judgment regarding the use of Article 356 of the Constitution to dismiss elected governments in the states. After reading the papers, the President expressed his displeasure to the Prime Minister and asked him to reconsider the Cabinet's recommendation. Prime Minister Gujral respected the President's views and did not reiterate the Cabinet's decision. In his memoirs titled Matters of Discretion, Gujral recalls, I quote him, "I requested the President and the Vice President to spare some time so that we could discuss the UP crisis after dinner. The three of us met in the President's private chamber. After 45 minutes of discussion, all of us were convinced that the dissolution of the UP Assembly by the Governor at the behest of the Government of India should be avoided, since, as the President put it, withdrawal of support is not a failure of the Constitution." The President, I continue the earlier quote, told us that he had studied the Bommai case judgment at length and also Sarkaria Commission's observations that the Governor must not do the head counting and the government must be made or unmade only on the floor of the House. This statement clinched the issue. I requested Narayanan to let me inform the United Front partners that I had failed to persuade the President. I felt that such a step would help me in watering down the enthusiasts, Gujral wrote. The enthusiasts' demand for sacking the UP government. He agreed immediately and gave me copies of the Bommai judgment and the Sarkaria Commission report. This was Gujral's memories. Once again, in 1998, President Narayanan demonstrated his justified constitutional activism and persuaded the Vajpayee government not to dismiss the Bihar government, then led by Chief Minister Rabri Devi, Lalu Prasad Yadav's wife. The President found no evidence of a constitutional breakdown in Bihar and returned the advice of the Union Cabinet for its reconsideration to then Prime Minister Atal Bihari Vajpayee, who also honoured the President's view. In one of his articles published in the Indian Express, the then Attorney General of India, Soli Sorabji, narrates the story in these words. I quote him, "As Attorney General, I had a meeting with President Narayanan. Thereafter, I conveyed to Prime Minister Vajpayee that the President's reservations were cogent and the President's rule in Bihar would be constitutionally vulnerable in view of the Supreme Court's judgment in the Bommai case." Of course, he used the word vulnerable as an euphemism. He continues, "Thereafter, the proposal was happily dropped." So this was the personality of President Narayanan, who saved the life of two governments, the democratic lives of two governments, and set the fine precedents for the Indian presidency, actually. Writes Malik, "Admittedly, the President is bound to act as per the ministerial advice, but the President is not a robot. He is a human being who applies his mind while appending his signature on papers. He cannot sign anything presented by the government, just anything. After all, there are a few areas where the President can act at his discretion without receiving any advice from the government. See, these are the exceptions. 1. Dismissal of the Prime Minister, who has lost the support of the majority in the Lok Sabha in Parliament but refuses to resign. 2. Dissolution or non-dissolution of the Lok Sabha Parliament on the advice of the Prime Minister who lost the majority support in the House. 3. The choice of the Prime Minister in a hung House where there is no certain majority. 4. Power to grant sanction of prosecution against the Prime Minister. Now, the President holds immunity from the judicial proceedings under Article 361 of the Constitution, and no court can compel him to appear in judicial proceedings. But he is not above the Constitution. If he violates the Constitution, Parliament can impeach him. Also, without making him a party, the Supreme Court can check the constitutional validity of actions taken by him which go against the Constitution or established laws. Generally, in all constitutional and executive matters, including the disposal of mercy petitions for people in jail or facing the hangman, the President acts on the advice of the Union Cabinet headed by the Prime Minister. After all, the President is the Prime Minister's man. That's true too. No Prime Minister sends an independent-minded person to Rashtrapati Bhavan. Well, not anymore anyway. Raisina Hill, the home of the President, is very powerful. No Prime Minister can take it lightly. That's the other end. India needs a President like K.R. Narayanan who ruled by the Constitution and protected the Constitution. Protected it at any rate. In this sense, the President is not a rubber stamp. In conclusion, Malik quotes these observations of eminent jurist Professor M.P. Jain. Quote, "The influence of the President, however, depends on his personality. A man of character and ability can exert a potent influence on the affairs of government with his advice, help and persuasion by using his knowledge, experience and disinterestedness to arrive at sound decisions on matters affecting the well-being of the people and not by his dictating any particular course of action to his ministers." Unquote. These are wise words to keep in mind as the electors prepare to vote in India's 15th President in these politically, socially turbulent times. This is your host, editor Inderjit Badhwar. Until next time, goodbye for now.
India Legal, stories that count.